Of the lawyers, it's available in CMA 8565. One day debate has been
good
placed.
150 pages.
Some parts of it have been placed on the file.
All I was trying to point out that the questions that your Lordship has raised, the Parliament also grappled with it. And in my humble view, these matters can't be looked in an isolation. Let's face it. I do not know how cases get fixed. I do not know how benches get constituted. I don't know how 184.3.1 case gets presented on the 12th of April and on the 13th of April it gets fixed.
So, Mr. Zahid Ibrahim,
this itself is a vindication of this law.
It can be fixed by the Supreme Court itself. So, if you point out
all the Parliament
to the
is saying,
Supreme Court
all
and the competent authority, which is the full court, which constituted, which promulgated the 1980 rules, they can revisit the rules and fix the issues.
Sir,
how does the Parliament come in?
Order 19 of the Supreme Court rules, Order 19 of the Supreme Court rules says that all appeals filed in the registry shall, as far as possible, be heard in the order in which they are set down.
Okay.
Does
so it's
it
a question of implementation. So according to you, the rules are already there, they are not implemented.
No,
so if it is incorporated in a statute, it would ensure implementation.
It is not incorporated in the statute.
Zahid Ibrahim, there seems to be a great fear regarding open door syndrome thing that's going on. So in this case, what we have to identify is whether there is a door or not. So if there is a door, there could come a law which could strengthen us, which would strengthen the Supreme Court, enhance the independence of judiciary. I'm okay with that coming in the door. But if something else walks in the door which affects my jurisdiction, reduces my jurisdiction, violates fundamental rights, access to justice, independence, I strike it down. So what's the fear? What is this open door syndrome going on?
It's a red herring.
And again, Mr. Zahid Ibrahim,
the main question is,
Mr. Zahid Ibrahim, all that the Parliament has done.
Yeah, door is the question that will determine.
The Constitution, for the time being, does not give a door to the executive or the legislature to interfere in the internal affairs of the Supreme Court.
So this bench has to determine whether it all is a door or not. What comes through the door is not my problem.
I think these proceedings are a classic example of how the jurisdiction or the power was exercised by the Chief Justice. As I pointed out earlier, there are a lot more important cases which never get a turn. Now here, everyone is saying it's a good law, but everyone fears this open door syndrome, as my learned brother has stated. I view it differently. The Parliament, since this court, having the power under Article 191, was even refusing to call a meeting of full court. And all that they did was to structure the discretion. They have not given any directions, and all that they have done is try to structure the discretion which this court was refusing to do, and there were obvious abuses.
And the unstructured discretion, my lord, we can close our eyes, but the public confidence in the judiciary has eroded. And we are all invested in this.
I think, Mr. Ibrahim, if I may ask you a question, assuming that this law is, I'm looking at the practice and procedure bits of it now, assuming that this law is intra vires the Constitution, in light of this law, who is the master of the roster?
Well, according to one judgment...
No. I'm talking of the law. In light of this law, who is the master of the roster?
I'm not sure where the term even master of roster comes from.
Who decides which cases get fixed where, etc., etc.?
The committee decides. The committee...
No, you're wrong. Committee is the creature and creation of Parliament. At its broadest level, this law is a claim by Parliament that Parliament is the master of the roster. And I'm asking you a question. You don't have to, as already pointed out by the Honorable Chief Justice, you don't have to agree with the question. To me, this is the crucial aspect of this law. It is not whether the committee consists of 3 judges or 5 judges, or Parliament says let the full court do it, or let the Chief Justice do it. Those variations, as has been pointed out, you said it, maybe that those laws will be made, maybe they won't be made, that's speculative. Whether it is speculative or not, I put that to one side. The point is, and this is the question I'm putting to you,
Yes, ma'am.
that in any of those scenarios, including the one that we have before us today, it is not the committee that is the master of the roster, because the committee is a creature of Parliament's will. Parliament has willed it into existence. Therefore, it is Parliament that is the master of the roster. Now, placed at that level, seems to me that this is directly in conflict, directly contrary to the principle of independence of judiciary. What would you say to that?
Can the master
I
of the
would
roster,
say- I would-
Mr. Ibrahim, can the master of the roster speak? I would add the word the purported master of the roster. When I became Chief Justice, and I had looked at it earlier also, the existing rules of the Supreme Court of 1980 stipulate simply that the Chief Justice will constitute benches. Now, practice had developed, maybe it's in accordance with the rules, I can't find it, that every week, list of cases prepared, a list would go to the Chief Justice, this case would go to that judge, and this case would go to that judge, and this case would go to that judge. I have discontinued that practice. This is not even the job of the Chief Justice. This is the job of the registrar. They can be given broad outlines, first in, first out being the general principle. Then there can be fast-track cases, election matters. Naturally, election matter will become redundant after a certain period of time, bail matters, etc. But to see even the cause list of the day and where it goes, I think, and this is the master of the roster speaking, please give this power so I can use it from the existing Supreme Court rules. Where do I have this power? I can't seem to find it. Can you help me with that?
And Mr. Zaid Ibrahim, there are no masters anymore in the world, you see. If you look around...
He always wants to undermine my authority.
With respect to the
lighter
master.
note.
No, but,
So I don't see that as a
think
master.
that
So
the
Mr. Zaid Ibrahim, what I want to say is that if you look at internationally, it's about time we wake up to the world, you see. We have US, UK, Germany, Brazil, Nepal, Philippines, just to name a few. There's no such thing as master of the roster. It's a collegial system that works, and that's across the board. And it's about time that we also woke up to all this, you see.
My lord,
With due respect to the master
with
here.
utmost respect, I say we need to wake up to what's outside this room.
You see if I may add to that,
And to answer-
under our system, and I don't mean to be disrespectful to anyone, masters come and masters go.
Yes.
This is not a lifetime appointment.
But while they are there,
No, just a minute. One Chief Justice may have one view of the matter, the other may have another view. And those who come, and I don't mean immediately, I'm not talking of potential Chief Justices sitting here, I'm talking even way into the future, they will do whatever they want to do. But that is not the important point. The ephemeral fleet more sense, that is in a sense beside the point. The question is within the
Invariably, through data, they have discovered that Chief Justice, if he has all the powers, he can manipulate cases. He can ensure a certain outcome. This is through data that they've presented. They've said that judges who have been dissenting, Subha Rao is one of the judges who dissented several times during his tenure as a judge. But as a Chief Justice, he never dissented because they would manage the bench. So this has been through data now established that if one person could get a bench constituted, get the judges on that bench, he could ensure the outcome. Don't you think that sort of directly hits at the core of independence of judiciary?
Of course it does. And
And
let me
again, Mr. Zaid Ibrahim,
I've also read the book that my learned colleague is talking about, and I look forward to having a. I've also read the book that my learned colleague is talking about, and I look forward to having a very enjoyable discussion about it with him. But the thing is, if the principle, it's the principle that matters.
Yeah.
If one man can do it, maybe 3 persons can do it.
Your Lordship
Maybe
has-
5 persons can do it. No, if you don't like following logic to wherever it goes, then the logical answer is everything should go to the full court, but that's practically not possible.
Mr. Zaid
The
Ibrahim.
point is, the principle of the thing still stands. My question to you still stands.
I
Yes.
want to have
Please
the
answer
opportunity
that.
to answer it.
Respond करें उसको.
The answer is in two. First, I would urge your lordships to not read this law as an encroachment into the independence of the judiciary. By no stretch of imagination is. Even in Parliament when this was discussed, it was discussed that the bar has wanted to do this for a long time. But PTI is challenging their legal counsel. Hamid Khan was cited in the debate as supporting this law. To answer your question, Parliament does not seek to be the master of roster of any.
Not a question of whether they seek to be this
Or they have
seek-
not.
Mr. Zaid Ibrahim.
The principle that is being established is that they are. Whether they seek it or not is beside the point. This is
Mr.
the
Zaid
core
Ibrahim.
of the question.
I would humbly say that it is not. And
in
secondly,
most of,
secondly,
Mr.
in
Zaid
relation-
Ibrahim,
Just on the
Sir,
lighter
एक second,
note,
most of the jurisdictions,
the only
the
way I
fixation
cannot
of
read
cases-
into this is to keep my eyes closed.
no, is to not chase
Mr.
shadows.
Mr.
I would say
Zaid
not chase
Ibrahim.
shadows. And just one last thing. My Lord, your Lordship had said that, oh, Chief Justices are there for 1 year, 2 years, they go, new Chief Justice come, and there's no, it's not you're stuck for this forever. But my Lord, what do we tell people who had homes in Nasra Tower? What do we tell people who lost jobs, employment, lives, property?
Mr. Zaid
There should
Ibrahim,
be a right of appeal.
ये देखिए, let this message not go out from this court that the constitution and the laws of Pakistan are dependent on who the Chief Justice of Pakistan is. This message must not go out from this court. The laws of the constitution and the laws of Pakistan are there, irrespective of the size of the Chief Justice's foot. So let this message not go out that the next Chief Justice can do as he pleases. Absolutely not. Let that be clear that what the law is, what the constitution is not a variable commodity subject to the whims and wishes of the Chief Justice of Pakistan. That must not be so. And if that is so, that is destructive of the constitution. It is destructive of the rule of law. It is destructive of the independence of the judiciary. It is destructive of everything. If we go that far and say, oh, let the next one come, he'll retire, 25th October, he goes, the next one will come, he'll do his own way. No, absolutely not. He should follow whatever is the proper method of doing things. It's not, sorry to say, if anybody thinks in that side, Parliament, or in any other situation that he becomes all powerful, I at least will not let this institution put forward this thing, we will do as we please. When we do. Here we have autocrats writing books, friends not masters. We don't want to even say that. I am not anyone's master. I am servant to the Constitution and an abd of the Almighty. That is the place to remain there. It should not be variable commodity. Oh, the next is what? How will he do it? So I don't. This is a very unhealthy sign. If it is so variable, then where the Supreme Court's change laws. A law is enacted today. The way it goes up, interpreted by one court, by the other court, by the higher court, by the time it comes to court, it's about 20 years for any law to see. Now, if it's such a variable commodity that we stump everything and we come 184.3, today the law of Pakistan is this.
Certainly, we look for consistency.
Mr.
And
Zaid
that's what
Ibrahim, I think, if I'm not wrong, most of the jurisdictions, they have adopted objective criteria for fixation of cases and constitution of benches, and have named as the natural justice. And they the concept of master of basis on the basis of a discretion vested in one person.
I think it's high time that we take mask.
In
समाअत जारी है। आपको बता रहे हैं वकील जाहिद इब्राहिम ने अपने दलाइल पेश किए। उन्होंने कहा कि 142 आर्टिकल के तहत कानून साजी के इख्तियारात दिए गए हैं। एक्ट के जरिए सुप्रीम कोर्ट के इख्तियारात को बढ़ाया गया है, जिस पर जस्टिस एजाजुल हसन ने रिमार्क्स दिए कि बढ़ाया उसी चीज़ को जा सकता है जो पहले से मौजूद हो। सुप्रीम कोर्ट प्रैक्टिस एंड प्रोसीजर एक्ट के खिलाफ केसेस की समाअत जारी है। वकील जाहिद इब्राहिम ने अपने दलाइल पेश किए। जस्टिस एजाजुल हसन ने रिमार्क्स दिए कि बढ़ाया उसी चीज़ को जाता है जो पहले से मौजूद हो। अपील का हक आर्टिकल 184 में मौजूद नहीं था। इस वक्त सुप्रीम कोर्ट प्रैक्टिस एंड प्रोसीजर एक्ट के खिलाफ केसेस की समाअत जारी है। वकील जाहिद इब्राहिम ने अपने दलाइल मुकम्मल किए। उनका कहना था आर्टिकल 142 के तहत कानून साजी के इख्तियारात दिए गए हैं। एक्ट के जरिए सुप्रीम कोर्ट के इख्तियारात को बढ़ाया गया है, जिस पर जस्टिस एजाजुल हसन ने रिमार्क्स दिए कि बढ़ाया उसी चीज़ को जा सकता है जो पहले से मौजूद हो। अपील का हक आर्टिकल 184 में मौजूद नहीं था।
एक्सट्रैक्ट्स और फॉरेन जजमेंट्स थे, मैंने अभी दिए हैं।
8301
आई अपोलोजाइज सर। सर I'll keep a mind of it. I'll be careful of it.
ये चला कर जीवन अगर निकाल
There should be a booklet in front of your lordships and the CMA. That is all I will be relying on. May I?
जी
Lord, first of all, there's a question of maintainability. At least as far as I am concerned, sir, I'll not be raising that issue. And for the reason that the last time I was on my legs before an 8-member bench, my argument was that due to the public importance and constitutional import of this case, it should be heard by a full court.
And आगे बढ़ें
sir. Now, on merit, sir, there are 3 questions to my mind. Firstly, can Parliament legislate regarding practice and procedure of Supreme Court and in any case override provisions of the Supreme Court rules 1980? Number 2, can Parliament create a right of intra-court appeal against orders under 184(3)? And number 3, whether even assuming the can be done, do the provisions of the 2023 Act otherwise somehow conflict with any provision of the Constitution? Now, before taking your lordships to the relevant entries and Article 191 and so on and so forth, I'd like to make some submissions, sir, regarding the overall conceptual framework within which I view this issue, and also the background and necessity of the legislation, especially since the petitioners and the counsel for the PTI have directly attributed a malafide political intent behind this act, arising from a desire to subjugate the independence of the judiciary. Now, I agree with the petitioners that issues relating to independence of judiciary do directly engage fundamental rights guaranteed under 9, 10, 10A of the Constitution. But there is a crucial difference between all the previous cases decided by this court, Meram Ali, Rawalpindi District Bar, Liaquat Hussain, Al-Jihad, etc., and this particular case. All the previous judgments of this court basically deal with external threats to the independence of judiciary. My humble submission is that this case primarily relates to internal threats to the independence of judiciary. It is what Asif Saeed Khosa, as his lordship then was, referred to as the final frontier of judicial independence. My submission will be that the constitutional guarantee of independence of judiciary covers both external independence and internal independence. Now, I'd like to start, sir, by reading two short passages from the article of Justice Khosa. He wrote this when he was a judge of the Lahore High Court. So this is page 1 of the booklet. And if your lordship will see page 4, I'll read a couple of passages from there, and page 6. So the second para, page 4. Now I come to the fourth stage, which I call the final frontier. In my capacity as a lawyer, I had written and spoken about independence of judiciary on several occasions, but now my perspective and angle are slightly different. Having spent a good number of years on the bench, I have seen the system from within, and thus I know and understand a few things which an outsider may not be in position to appreciate. In this background, I intend to share some aspects of independence of judiciary which are generally overlooked. But these aspects are so important that without attending to them, the whole superstructure of independence of judiciary remains incomplete, and if I may say so, shallow and superficial. I'll skip a para, sir, to save time, then the para after that. It is some of these areas and aspects, often ignored and overlooked, which I intend to highlight. The earlier stages I have mentioned are essentially relevant to threats to independence of judiciary from outside the judiciary. But the final frontier envisioned by me is the stage where independence of judiciary is achieved through a successful passage of the earlier stages, is to be protected from the threats originating from within the judiciary itself. Three areas appear to me of particular importance in this context: independence from oneself, independence from judiciary, and independence from justice. Now, if your lordship will turn the page to page 6.